Good morning. Happy Tuesday. Welcome to the Courtroom Files Live. We will start our day in Michigan with Judge Middleton.
He's not allowed to possess ammunition, and the matter was charged as a felony. He is on bond on 3 other felony cases, which are all bound over to the circuit court. And he was charged with this. Judge Pattison set the bond at $10,000 cash or surety with certain conditions, including supervision of the community corrections office and drug testing. The defendant was here on, I believe, May 13th for a pre-exam conference with Mr. Truckee, and indicated at that time he wished to have a preliminary examination. So the preliminary examination was set for May 20th. And I'm going to represent what I was told, so anybody can correct if it's different. At any rate, the defendant didn't show up on May 20th. Police officers were here prepared to testify, much to the consternation of all of us, including me. So I issued a bench warrant and set bond at no bond. I wanted to see you personally. Then I went on a trip. I came back on Tuesday, May 27th. I believe it was, this occurred the following day. I may have my days mixed up. I thought it was Wednesday, the 28th. At any rate, there was a warrant out for Mr. Fuller's arrest for failing to appear at that hearing. He called the court that day after the 20th and said, in the afternoon of the 20th, so I missed my court date. And they said, well, there's a warrant for your arrest. Between the 13th and the 20th, Mr. Fuller came into the court and paid some payments on a payment plan that he was on for some other cases. So between the 13th Tuesday and 20th, they didn't show up. He was actually in the courthouse and paid on some fine. So he didn't show up on the 20th. Then he presented himself at the court. Now, Mr. Truckee or Mr. Fuller, you can fill in the details here. My understanding is Mr. Truckee told him to turn himself in at the jail. Rather than meet him here at the courthouse, Mr. Truckee was here that morning. He told him to turn himself in at the jail. My understanding is, and correct me again if I'm wrong, he went to the jail and sat there for about 45 minutes, but they said they were too busy to book you in. Is that true?
Yes, sir, Your Honor. So
you came from the jail to here. So I'm in the middle of a busy morning with a bunch of other stuff going on, and here you are. So you walked, Mr. Truckee walked out the door, you walked in the door. So he was gone. We tried to call him, but he was already on his way to Three Rivers. So here you are. I canceled your bond. It was my bench warrant. And there's a statute that nobody likes, but it's MCR 6.105. It's actually a court rule. If a defendant wanted on a bench warrant or arrest warrant voluntarily presents himself to the court on that warrant within 1 year, the court must either recall the warrant and schedule the case for a future appearance. It is presumed that the defendant is not a flight risk when the court sets a bond order or other conditions of release at arraignment. So that's what I did. There was another option. You can arraign the defendant if the court is available to do so within 2 hours of the defendant presenting himself. So he'd been to the court between the dates. He called the court the date he missed. He went to the jail to turn himself in. They wouldn't accept him. So I went with option 2 of the court rule, which allows him to be presumed to not be a flight risk and appear, which he did. Mr. Truckee was scheduled to be here this morning. He was late. He did call and said he was running late, but he's here. I didn't give him a PR bond. I simply recalled the warrant and reinstated the $10,000 cash or surety bond that was in effect. So it's like, okay, no counsel was here. Mr. Stickley wasn't available. Mr. Truckee had left. I didn't give notice to the prosecutor. I simply scheduled the matter for this morning. And then went on back about my business because I had other stuff to catch up from being on vacation. So some point later that morning, Mr. Gabriel came into my chambers. I was in there signing some orders and I said, hey, good morning. I got something I'd like to talk to you about. I had a misdemeanor complaint that was handled by their intern that I wanted to check with him on. And he said, I have more important things to talk about than that. And he said, why in the hell would you give Karan Fuller a PR bond? And I didn't have an instant response, but I didn't give him a PR bond. I just recalled the bench warrant. And then I said, well, I guess I'm sorry I didn't give you notice of the proceeding, but he just showed up and I cited the court rule. So I set it for today. So Mr. Gabriel was quite upset. He got up and either said, this is disgusting or you're disgusting. And he walked out of my office. And this was ex parte. Nobody else was in there but us. And so I left sitting there thinking either me, now maybe the statute is disgusting or court rule that there's a presumption if they turn themselves in, that they're not a flight risk. If I had done that when I was assistant prosecutor to Judge McManus, Bob Karras would have fired me that morning. When did it become a thing that the assistant prosecutor could come in and tell the judge that he's disgusted by a ruling that he made? I'm not sure when that became appropriate. I don't believe you do it to Judge Stutzman. I don't believe you do it to one of the judges in Kalamazoo. I followed the law. I had an understanding of the facts. I followed the court rule. I set the matter for hearing. He's here today. The offense he was released on was possession of 2 shotgun shells. I don't have the discretion to cancel this bond because Gary Gabriel is mad at him. And I didn't deserve what you came in and said to me. In my career as judge, you've been the most disrespectful attorney to me, bar none. An attorney came to me after a hearing and said, how long do I have to be a lawyer before I can be as much of an asshole as Gary Gabriel was to you? I don't deserve that. And I didn't deserve this. I followed the law. I had a better understanding of the facts than you did. I had a better understanding of the law than you did. And he's here now. Make a motion to cancel his bond in circuit court if you're that upset about it. I'm going to send him for a drug test here before we're done this morning. This violates the canons of professional responsibility. You have an obligation to treat the court with respect and your other lawyers with respect. And I understand that you were upset, but you left before I even got a chance to explain myself. So that isn't a thing. The assistant prosecutor can't go into the judge's office and say, your ruling sucks. That's not how it works. So I didn't deserve it. I don't deserve it. And I believe I was right. And he's here now. We're going to have a drug test. You have your right for a preliminary examination, which will be next Tuesday at 1 o'clock, and we'll proceed accordingly. So what I expect is you to apologize. I understand that you lost your temper and you're upset about it. And that's to be understood. Nobody liked Court Rule 6.105. It was very controversial with the judges. You either had to let them go or drop everything you're doing and arraign them within 2 hours. And as I said, he had turned himself in at the jail and they wouldn't take it. So I set it for this. So that's all I have to say on the matter. Ms. Davis.
Thank you, Your Honor. First, I would like to say that we were not aware of Mr. Fuller attempting to turn himself into the jail. But that's the first I've heard of it is today. We'll certainly be following up with that. Our belief is that the bench warrant arraignment is a critical stage and that he should have had an attorney. We had made it clear at the last hearing when the request was made that we felt that Mr. Fuller was a continuing risk. He was involved with felonies. He's not new to the system. He knows how this works. He knows where he's supposed to be and when he's supposed to be there. His pattern of behavior towards law enforcement is extremely dangerous, with fleeing and eluding and resisting and obstructing. And in order to protect society and give our law enforcement the support that they deserve too, we were asking that his bond be canceled and that he be remanded. The concern is now that he continues to be around people who use substances. So his history and not showing up, I'm thankful that the court is going to have a test done.
Well, let's assume that all that is true. What gives him the right to come into my office and express his disgust for my ruling?
Your Honor, I don't believe that it's not appropriate. I get that. We are in a very difficult situation in our office in light of everything that has happened in the last year and a half. So it's been very difficult. It's been very stressful. And I think overall, Mr. Gavery has the same philosophy that I do as far as holding people accountable and taking action so that people know that if they do get in trouble, we're going to hold them accountable and not just allow people to waltz in as when it's convenient for them. It's not convenient for any of us, and we do our best to have somebody available at all times so that if there is an emergency hearing, the court can call down and we will get somebody here. So what happened, the way it was described to me was different than what
well, there's two sides to every story.
Correct, and there's perceptions. So I know that Mr. Gavery apologizes for the.
I don't want to hear it from you. I want to hear it from him.
I understand it. We'll give him a chance to speak in just a moment, but from the beginning, it was my understanding that the comment was made as far as the whole process, because we feel like we're doing our best to charge, hold people accountable, and show up whenever we can.
Well, we've got a case where he's charged with possessing 2 shotgun shells. Move to cancel his bond in circuit court. If you could, I don't want to hang my nail on canceling a bond for someone who was here in between, called the court, went to jail, and the law doesn't require that I give notice to the prosecutor. I had one of these yesterday. I have one almost once a week. Somebody shows up. So he's here. You're right. He keeps doing stuff, or try one of the cases. He's got 3 cases bound over to circuit court. He got charged with a crime, got arrested again, no motion to cancel his bond in circuit court. We set his bond at $10,000 cash or surety with conditions. So it isn't like we're just saying, please don't do this. But it would have been an abuse of my discretion to cancel this bond for not showing up on a case where he possessed 2 shotgun shells. So I set it for this hearing, and he's here, and we're going to drug test him, and you can have a prelim next week.
Thank you, Ron.
And your support, Mr. Gabriel.
First of all, let me say without any equivocation that I apologize for losing my temper, for addressing you more as someone that I have known for my entire career in criminal justice, someone who with me taught a number of even elected prosecutors right now how to try a case, how to be a prosecutor, what the ethics are involved in prosecution. In my 45 plus years, I have never been held in contempt. I have never disrespected the court when on the record. I have always prided myself on not only doing the right thing as a prosecutor, but also protecting the community's interests and law enforcement's resources. The comment that I made to you would never, Your Honor, and I think you know this because you and I know each other, our wives know each other, we've spent time on Mackinac, would never indicate my disgust for you as a human being. I have the utmost respect for your career. I do, however, differ with some of your handling of matters, one of which is your live stream. And you are aware that I took an opinion about that the last time I was here. I still come to court when I can. I was brought in here to handle circuit court with the idea that this office might be able to get back where it should be before the last prosecutor dismantled things with his blatant accusations against my present boss. That's why I'm back here, because I believe in this prosecutor. I believe she's the first one you've had in a while that wants to do the right thing. And the right thing, just like it was the first time I was here for a while, was to hold the people that are putting a huge burden on the citizens in this community, to hold them accountable. My anger and my disrespect was directed towards a feeling that I have that this court expects a lot of its prosecutors to be here, to just wait, to address things that, as I just conveyed to the chief judge, one of the few counties I've ever been in as a prosecutor or a defense attorney where prosecutors appear routinely at sentencings. It just doesn't happen anywhere else. Why? Because they're busy. Well, we're busy. We have 3 people. One of them is the elected prosecutor, the newly elected prosecutor, who has her hands full, just trying to correct the errors of the past year. That leaves me handling circuit court and helping out in district court, while Mr. Robert is helping out in district court and also spending a lot of time in Three Rivers. So yes, there is a lot of pressure on this office. Did that enter into my feelings of disrespect for how this system operates, directed towards you, Judge Middleton? There are times when I lapse and I have to think to myself to say Judge Middleton, because we've known each other a long time. I will, if I can, be honest now, not that I haven't been up until now. You will recall that while at that prelim, I came in here and I advised the court right away that I had been working and trying to get Mr. Truckee to let me know whether Mr. Fuller was going to waive or not waive, that I had talked to Mr. Truckee about what would happen if I'm going to have to bring officers to come in and sit as what you call kind of so what case. Well, they came and they waited and they waited and we waited. I looked at this young man's record, this 34-year-old man, and I saw bench warrants just like this on the Walmart case and the stolen car case, where he was supposed to be here. And ups, it got adjourned, come back. I think Rhonda Ives, nope, no bench warrants issued. In this situation, what happened from our perspective that day was I appeared at the prelim. I respectfully laid out why I thought it was appropriate that his bond be canceled, that a bench warrant be issued so that he could be brought before the court. And I knew he was going to get another bond, or at least we might find out, A, is he around? People assumed he was. I don't assume anything. All I know is he was supposed to be here. You did a bench warrant. I checked when you were gone because Mr. Robert pointed out the ROA was confusing, that it sounded like he was to be something about arrest, but the warrant was there. So I talked to Judge Pattison. We went to the district court. We clarified the day before he walked into court that the bench warrant was valid. Mr. Truckee had told him to go to the jail. And I knew nothing about him coming in here, certainly knew nothing about him going to the jail. I knew nothing about him coming into the court when there was a warrant, and nobody in security notified us. What I was notified of was when my prosecutor walked in that morning and said, I just saw Karan Fuller riding a bike or something down the street. What's going on? So I go up to security and they tell me, oh, he came in and Judge Middleton let him go. That upset me. It upset me because I thought that because of the respect that I've always shown this court, my willingness to try to be here to do what I can to help out, that I would have been notified of something when I'm sitting in my office looking at my cases. I want to know why he wasn't here. That's usually what happens in circuit. They get arrested. Why were you here? Well, my mother was sick. Okay, we'll reinstate the bond. Something to impress upon people that the court means business. And that's all I ask as a prosecutor, that the message that gets sent through this live stream, through our appearances in court, means something. Not comments like on the record, well, it's not the crime of the century. Or it's a pain in my neck
He said he's a
when this
pain in the neck,
happens.
yes.
Pardon me?
Yeah, he is a pain in the
Right.
neck.
But he's more than that, Your Honor. He shows disrespect to you too. Your statement that you made about, well, it's more trouble to book you in and then book you out.
That's true.
It is. But that's the system that's in
Well,
place,
all right,
isn't it?
listen, I agree with everything you said.
And
But
let me finish and then I'll take my admonition. I do not recall that you ever indicated or that I indicated a PR bond. I didn't know what happened. All I knew is you let him, they told me that you let him out. I didn't hear the court rule cited whatsoever. That I think would have been the thing that we might have done on the record had he been brought in and Mr. Truckee held here or held in the jail and held in lockup until Mr. Truckee got back, because I'm interested to know what kind of contact, if any, he even had with his attorney after he walked out of here. Those are the kinds of issues that go into my decision on whether I'm not going to use additional resources to just simply file a motion in front of Judge Stutzman and bring Ms. Ives in and bring everybody else in because of the multiple attorneys that get involved here. So there are a lot of things that I like to discuss. And I think if you talk to the chief judge, you'll hear that we talk about ways to try to improve the system, to try to make it more efficient, to try to make it work with just three of us. So yes, I was angry. Yes, I regret my comments to you, and I regret losing my temper. I don't want to be seen as that way, but I have been doing this for pretty close to 50 years. And I've seen it all. And I've been a judge dealing with parolees going back in front of me on the pro board. I know what it is to disrespect someone, and I feel bad that I did that. And I feel bad that I did it to somebody that I in the past considered a friend. I hope you will accept my apology for that and recognize that the frustration that I have is not because I'm lazy. It's not because we don't want to be bothered. It's because we want to try to make the system work for the people in this county, the people that are paying a lot of money. My last comment that I wrote down when you were talking is what you said about the court rule. And I will say, I don't have that memorized. I haven't really experienced that before. Nobody's ever cited it to me. The way it's been handled is what I just outlined. Come in, hear your story. Why did you do? Ask the defense attorney, what kind of contact did you have? Usually there's the admonition. I'm going to let you out. You're going to be in touch with your attorney. You're going to be on time, not 10 minutes late for court, like this morning.
We went through that.
Okay. And is he, not presumably a flight risk? Let's not forget that this case in which he faces life or any term of years because of his past record, is right on the heels of a case in which he led law enforcement through this little town in a high-speed chase while he allegedly was carrying meth and a gun. So this man is bordering on heading into a lot more serious. And it seems to me, and again, I'm not going to go into comments that you and I had off the record about your past dealings and family's dealings with Mr. Fuller. But yes, I was upset because I have a perception that this is not being treated seriously. And for that, I apologize.
All right, your apology is accepted.
Thank you.
Within the week, Judge Pattis and I had a discussion just before I went on my trip about what an asset you were to the prosecutor's office. You can try a case in circuit court. You're willing to do misdemeanor pretrials. You show up at sentencing and do appropriate, thoughtful comments. And Judge Pattis and I both believe, I'm sure Judge Stutzman too, that you're an asset to your office. The office wouldn't function without you being there. You and I go back 45 years, which is in part why you thought you could come in there and unload your anger on me. Yes, we taught a generation of young prosecutors how to be a prosecutor, including our current attorney general. But this case isn't the one to hang it on. Now, we'll have a drug test, and I have my suspicions of how that's going to turn out. And we'll have a prelim if necessary on Friday. When all the cases are in circuit court, perhaps you can file a motion to cancel this bond. But that's up to Judge Stutzman, and he's got multiple counsel. I think there was an effort to try to do everything together. Anyway,
Your Honor.
I regret that this whole thing happened. I discussed it with the chief judge when he got back, said, how should I deal with this? I don't think it deserves a grievance. All I wanted was an apology, and I got one. And the case will move forward, and the defendant is here as under the court rule. And I said, nobody liked that court rule. It was probably the least popular in the whole criminal justice reform package, but I'm bound to follow the law. Yes?
You had mentioned the prelim on Friday.
Excuse me, I'm sorry.
Okay, just want to make sure.
No, Tuesday,
Tuesday,
I don't want to make any further confusion. Tuesday, June 17th, 1 o'clock, Mr. Fuller, you're to be there at that time. I want you to go directly from me.
I'm sorry, June 17th or the 10th?
Boy, I'm all screwed up. June 10th,
Okay.
next Tuesday,
All be on the same
June
page.
10th, not the day we've been using for the others. Once you go to the day reporting center right now, we'll do 11 panel test. We'll figure out who's going to pay for it, but it'll be paid for.
Yes, sir.
Then it may take a few days to deal with that. We'll deal with the results of that at your prelim next Tuesday. All right, you're free to go. We'll let the day reporting center know that you're coming. Laura, will you call them and tell them Mr. Fuller's going to stop there for a 11 panel urine test?
Thank you, Your Honor.
Thank you, Your Honor.
This matter is completed. Let's bring Ms. Welch in and deal with that matter.
Security has concerns that she is detoxing. I did meet with her. They believe she's in her beginning stages, so she is a little fidgety.
Would you, well, let's see.
Anxious, so.
She's positive for opioids and methamphetamine. If we wish to continue it, her family's here.
So yeah, that's an interesting way to start the day. Good morning, everybody. Welcome to the Courtroom Files Live. I was not expecting that when I queued up Judge Middleton, but I'm so glad we caught it. In my mind, it shows two sides of how people approach their work environment. You have Judge Middleton, who's trying to stay fairly even keel and handle things in a logical manner, and then you have people that almost take their work too personally, and I think that's the case there. I think he gets that guy just got way too emotionally involved in what was going on, and it could have cost him a lot as far as his job went if the judge had handled it differently, and it certainly could have cost him. Probably did cost him, at least in part, his friendship with the judge. So interesting stuff. Let me know further what you think in the comments. Obviously, while I was talking there, judge went offline. Let's go to Fulton County, Georgia, where they are doing their multi-purpose calendar, I believe.
Anyone forced or coerced you to plead guilty? I'll accept the plea as negotiated, Mr. Akins. When you complete the terms of the probation, when you get the community service done, I'll have the probation terminate. So the sooner you get it done, the sooner you won't be on probation, okay? Good luck to you, Mr. Akins.
Position 9 and 10, Mr. Diggs.
What are we doing with Mr. Diggs this morning?
That'll be a negotiable plea, Judge.
Okay. Good morning, Mr. Diggs. I'm Judge Eric Mara. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? Okay, you can place your hand down. Thank you, sir. Yes, Ms. Paul.
Yes, Your Honor. As to Mr. Diggs' cases on position number 9, the state's recommendation as to the offense of battery is 12 months, serve 104 days, credit for time served 52 days. That is from December 17th to December 19th of 2023, July 2nd to July 3rd of 2024, and April 18th, 2025 until today. Balance probated, no further contact with Joy Hakeem. Stay away from 2885 Skylar Mill Lane in Snellville, and no firearms, 12 weeks of anger management, and 40 hours of community service. In this case, we did have an opportunity to speak with Ms. Hakeem. She agrees with the plea, and she stated she may be here on Zoom. So at the conclusion of the recitation of facts, we would like to sound for her on position 10. The failure to appear, the state has agreed to null process this upon acceptance of the plea. We would at this time like to sound for Ms. Joy Hakeem, and that's all for the state. Oh, we do ask the defense to stipulate to venue factual basis and identification for the purposes of this plea. That's all for the state.
Good morning, Ms. Hakeem. If you would like to address the court, now is your opportunity. You certainly do not have to, but if you would like to address the court, I need for you to unmute yourself and I'll have to swear you in.
I'm unmuted.
Okay, if you'll raise your right hand for me, please. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can place your hand down there. What would you like to tell the court?
I just want to thank everyone on here because I feel heard now. This case will be 2 years old in October. And honestly, it took some time to heal from this, but I'm okay now. And I do want to say I forgive Mr. Diggs, and I've made amends with myself. This situation has only allowed me to grow. So I do want to say thank you to everyone who has helped me with my case.
I appreciate you being here this morning, Mr. King. Thank you. Mr. Haddad?
Judge, we stipulate to venue, factual basis, and identity. I would ask the court to follow the state's recommendation. Also ask the court to consider, based on the class that he has to take, to consider waiving the first 3 months of his probation fees, Judge.
Okay, Mr. Diggs, it's my understanding that in case 23 CR 008037J, you wish to plead guilty to battery, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time? You've been represented by counsel. Are you satisfied with his representation? Do you understand that you have a right to a trial by jury on this charge, and by pleading guilty to it, you're giving up that right?
Sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Diggs. When you complete the terms of the probation, I'll have it go to a non-reporting status. You'll still be on probation, but it won't be reporting and you won't have to pay those fees. Sooner you get it done, the sooner you won't have to pay the fees. Good luck to you, sir.
Thank you, Judge.
South Annex is on.
Let's go back to Judge Middleton's court. He's back online.
Previously, this has been going on for about 5 years.
Yeah, and you're 20. Ms. Davis, you were astute in asking for a final test rather than just her representations. Anything else you wish to say here?
Your Honor, after the hearing yesterday and hearing what substances she was positive for, obviously the concern was that she's on bond for what were felonies reduced to a misdemeanor. At age 20, she has got an addiction that is so significant that she can come into the courthouse with those substances in her system and still appear relatively, quote unquote, normal, speaking, walking, not passed out. I did inquire from an individual that knows her from school to see what was the background here. And I don't think that Natalie realizes how many people care about her and are pulling for her and want her to do well, and recognize that she had a very difficult upbringing, very difficult family situation, and perhaps that's not the healthiest place for her to be in order to be sober. With that in mind, I would ask the court to consider doing a period of 90 days jail up front, that if she is able to get into an inpatient rehab facility, that she'd be allowed to do that, but it would be as a term of this so that she wouldn't be able to just voluntarily sign out. And that upon completion of the 90 days or completion of that inpatient, that she would then be on probation. I would request that it be 2 years based on the length of time that she has had these significant issues, and the fact that while on bond, she has admittedly continued to use and hasn't been able to kind of seek out the resources that can help her. So with that, I would ask the court take that into consideration. Thank you.
Thank you. Yeah, it's an absurd situation we're in. The law, more of the Criminal Justice Reform Act, presumes everybody's going to be free on bond. There's a presumption that there's a PR bond, and certainly a presumption of bond. We used to do drug testing at the Day Reporting Center. We had funding for it from the Community Corrections Grant. Now we just tell people that are addicted, don't use any drugs. And the point of fact is almost everybody would test positive between the date of the pre-exam and the prelim because they're addicted to very powerfully addictive substances. You scare us, Ms. Welch, because there's so many things involved here and you're so young. People don't die from methamphetamine overdoses. They decay over time, and we've certainly seen it. People die from fentanyl overdoses. You got other stuff in there, including cocaine, and some other, and marijuana, and perhaps other prescription stuff. It's frightening. I talked to Mr. Frazine on the phone this morning, and I think we're all on the same page. You need some sober time. We're going to try to see if we can find an inpatient treatment program for you as a condition of your probation. I can amend your jail sentence to let you into an inpatient program. And that's what Ms. Davis suggests. That's what Mr. Frazine suggests. But you need some forced clean time. So I agree with Ms. Davis. You need 24 months of probation. I'll follow her recommendation. I'm going to order 92 days credit 2, leaving 90 days to serve. The fine is $0. There's a $75 crime victims' rights fee, $50 state minimum fee, $150 attorney fee, and a $960 probation oversight fee. You don't have very much money, so this isn't so much about money. 12:35. No drugs and no alcohol. Test as directed. Also need other treatment. May be released to an inpatient treatment facility if we can find one. So it could be as soon as the one as would be available, I suppose. But it'll be the kind of probation that Ms. Davis reflects, that you can't just walk away from it. If we sent you to a treatment program, it'll be a condition of the probation that you participate in it. And if you walk away, it will be a violation of your probation. It'll be back in jail. But right now, you're gonna have a rough couple of days.
I need to watch that.
All right, I don't know, she'll be in the jail for some time, potentially as long as 90 days minus good time, which would be 75 days. But I'm envisioning that between then, before then, maybe sooner rather than later, we're gonna get you into an inpatient program. I don't know where you're getting these drugs. They weren't trace amounts. They had usable quantities of meth, cocaine, fentanyl, and maybe heroin. Spooky. All right, I don't wish you any ill. I really don't. We've seen you before. I've been here for a long time. And I see what the toll of drugs do to a 20-year-old girl over a 20-year period. And it isn't pretty. You deserve better. So you're gonna go to jail. You're gonna be there for a while until they can find a place for you to go. Do you have any questions? I understand Autumn kind of was hard on you yesterday back in the lockup. I think she gave you some good advice. You deserve better than where you're headed. So let's see where we can go. So you're free to go.
Well, hopefully she gets it together. I can't recall if we watched her on the live yesterday or not, but I know I saw her. And they were really concerned about the drugs that she had in her. So, again, hopefully she gets together. That's a young lady. Let's go to Florida. This is Judge Anna Garcia. She is doing felony arraignments.
Possession of controlled substance, a third-degree felony, punishable up to 5 years in prison. Count 2, possession of paraphernalia, first-degree misdemeanor, punishable up to 60 days in jail. The agreed-upon sentence as to count 1, he'd be placed on probation for 24 months. He'll be adjudicated guilty of the felony. He'd pay court costs and fines while he's on probation in the amount of $1,100. He'd receive 30 days jail credit. He must complete 100 hours of public service work at a minimum of 8 hours per month, $20 a month cost supervision, undergo a drug and alcohol evaluation, apply with any counseling is recommended. I've advised him that the Department of Motor Vehicles may apply additional penalties based on the adjudication of the felony drug offense. He get time served, that's to count 2. We stipulate there's a factual basis for purpose of the plea. We'd waive a reading of the court costs and fines. I'm not aware of any DNA evidence that would exonerate the defendant.
All right. Mr. Whiting Jr., if you will, please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You can put your hand down. Is this the agreement with the state?
It is, Your Honor.
Is the state aware of any exculpatory DNA?
The state is not aware of any.
All right. Mr. Whiting Jr., tell me your full name for the record. Mr. Roberts, will you switch the mic?
Timothy Lamar Whiting Jr.
Sir, did you hear what your attorney just said about resolving your case?
Yes, Your Honor.
Is that how you wish to proceed?
Yes, Your Honor.
Has anyone promised you anything other than what he just said to get you to enter into this plea?
No,
Is anyone threatening you?
no.
I have in front of me a 2-page plea waiver and consent form. This is the first page. This is the second page. Did you sign the document right there?
Yes, Your Honor.
Did you have enough time to review this document before you signed it?
Yes, Your Honor.
Have you had enough time to talk to Mr. Roberts about your case and about this plea?
Yes, Your Honor.
Are you satisfied with the advice and counsel that you have received thus far?
Yes,
Do you understand that by entering into this plea today, You are giving up your right to go to a trial where the state has to prove these allegations against you.
Yes, Your Honor.
Do you understand that you're giving up your right to present any defenses that you may have?
Yes.
And do you understand that you're giving up your right to appeal anything except an illegal sentence?
Yes.
Are you doing this of your own free will?
Yes, I am.
All right, Mr. Whiting Jr., you're also pleading at what we call the arraignment stage, okay? Because you are pleading at arraignment, like your attorney said, he has not had the opportunity to participate in the discovery process. During the discovery process, your attorney would turn to the state and say, give me all of the evidence that you have against my client. Because he is trained in the law, once he takes a look at that evidence, he may be able to say, hey, you've got a defense that you don't know exists as you stand here today. Are you sure that you don't want to participate in that process in order to take this plea today?
Yes, Your Honor, I'm sure.
All right, fair enough. Mr. Whiting Jr., I find that your plea is knowingly and voluntarily entered into after the advice of counsel and that there is a stipulated factual basis for purposes of the plea. I will now proceed to sentencing unless I hear otherwise from either the state or the defense. Mr. Whiting Jr. in Jackson County case number 24 CF 593, I accept your plea of no contest to 1 third-degree felony count possession of a controlled substance, 1 first-degree misdemeanor count possession of paraphernalia. I adjudicate you to be guilty of both and sentence you to time served on the misdemeanor. On the felony, I sentence you to serve 24 months state probation. I order you to pay court costs, fines, and fees in the amount of $1,100, give you credit for 30 days you've served in jail. I order you to serve 100 hours of community service work. It will not be at any specific rate per month. However, if you participate in a class called Face It through probation, and they'll tell you about this, if you do it within the first 60 days after the sentence, you'll get, it's a 2-hour class and I'll give you 10 hours of community service for it.
Okay.
Okay, so it's an easy way. Face It basically just teaches you what probation's like and how to be successful. So I think it's a beneficial situation anyway. Okay. I order you to pay $20 a month for cost of supervision. I also order you to undergo a drug and alcohol evaluation within 30 days.
Yeah.
If that evaluation recommends any counseling, I order you to complete the recommended counseling. It's important that you understand that there will be zero tolerance for the use of drugs or alcohol while you are on probation, and you are subject to random urinalysis at your own expense. I also advise you that the Department of Highway Safety and Motor Vehicles may impose additional penalties, and I order you to forfeit all items seized.
Yes, Your Honor.
Mr. Whiting Jr., do you have any questions for me about the sentence that I have just announced?
No, ma'am.
Is there anything further from either the state or the defense? All right, then, Mr. Whiting Jr., I am required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. We're going to need your fingerprints, and I want you to step to the side to speak with Ms. Jernigan. She's our representative from state probation, okay?
Thank you, Your Honor.
Good luck, sir. Mr. Roberts, I need to jump in on a special situation. Can I have just a minute? Ms. Kelly, are you with me?
I am, Your Honor.
And is Judge Mercer still on? All right. Can you get with Chris and see about tying in the jail? Ms. Kelly, we're getting Derek, will you stand in? Well, no, you can't. You're recused. Do we have the family of Miss Willie Ruth Pittman present in the courtroom? Can I have you guys come up, please? Amanda, can you guys please come up to this bar right here where the attorneys were? Amanda, we became aware that the family was going to be here, and so I'm just going to have them come up. Mr. Roberts, Mr. Pittman is sitting. Mr. Roberts, Mr. Pittman is here also. Would you mind standing here? I'm good because he'll be there. Family of Miss Willie Ruth Pittman, please come on up. And we're getting her from the jail. Ma'am, tell me your name for the record.
Annie Black, hello, and I'm Willie Ruth's sister.
Excellent. Thank you. Good to meet you. Sir, tell me your name for the record. Okay. Thank you for being here. Thank you. And Mr. Pittman, hello. Good morning. Guys, we're waiting to get the jail on. Judge Mercer was using that jail room, and so just give us a second. Ms. Kelly has now been appointed. Ms. Kelly's on the video screen. She is now Miss Willie Ruth Pittman's attorney. Mr. Roberts is Mr. Pittman's attorney in this matter. Okay. Amanda, for your information, Ms. Pittman, as you know, has charges in Washington County, And I spoke to Judge Peel on an unrelated matter today. And I also, because I think you guys are pleading something from Jackson over there, a felony petty theft. I'm assuming Megan has talked to you guys about it.
I have not specifically spoken with Megan about that case.
A felony petty theft. I'm sure she'll reach out. In any event, I told him I'm fine with whatever the state and the defense agreed to. But Amanda, Judge Peel and Judge Register are okay with us resolving Ms. Pittman's cases as a global, depending on how they're ultimately resolved. Okay, so just give me a minute. Is he connecting? Did you tell him we needed to connect? Okay. Do what, hon? No. Chris has to, it gets hinky when someone else was using the jail, and so we need to wait for IT. How has she been at the jail? She seemed calm on Friday. When did we see her, Derek? Friday? She seemed calm on Friday. Is she calm or is she not calm? Just calm and okay. Family, you may or may not know, Ms. Pittman had law enforcement contacts probably daily while in Jackson County because of her erratic behavior. Batteries on law enforcement, spitting on people. Randall, right?
Yes.
Randall shared with us in court last time that she would often be in the middle of the street naked, potentially having an issue of being run over by vehicles. And so ultimately law enforcement filed criminal charges because of the continuous batteries. Are they getting her? Will you let them know? So Amanda, why don't you bring us up to speed? Have you had an opportunity? Well, let's wait on her and see if she can understand what's going on. There she is. Ms. Pittman, good morning. Ms. Pittman, your sister's here in the courtroom with us. And she is. She's here on your behalf.
I have 1, 2 days, youngest day, and the oldest day. I have one of the orange kind and the color.
What's she saying, Randall?
She said she had one sister left. She has 2 other sisters.
I'm happy for you to tell her hello if you wish.
Hey, where you went, huh? Hey, Rain.
Hey, Mama.
Hey, where are you going? Where you hiding now? In the
Ladies,
truck?
are we on camera?
I'm home.
In the truck?
In the
So
truck.
what's your
I'm not in the
favorite
truck anymore.
auntie? I'm
home
in
now.
my house, and on the shed. Where y'all hiding at?
Sister, I'm
I'm
okay if you
on
want to say good
camera.
morning to her.
Good morning, Willie. You recognize Possum, your sister Possum? How you doing? That's your orange kind. Where y'all come from?
All right. Miss,
You ain't funny.
guys, listen
You
carefully
funny.
to
You definitely.
Willie Ruth. What's going on with the audio?
Good morning.
Amanda,
Miss
I'm
Willie?
happy for you to tell her good morning, but hold on, we're having trouble with the jail audio.
Okay.
She's cussing them out.
Chris is probably watching.
Is somebody muting it, maybe?
No one's muting it.
Well, she's fussing them out now, so she so she
No.
might be muting it.
No, we would
Okay.
see they have to press a button right
Okay.
there, right? Yeah, so they're not muting it. So we've had a little bit of trouble with the jail audio lately.
Okay.
May I ask you a question?
Yes, ma'am.
Okay, she's obviously a long time been mentally,
Yes, ma'am.
incompetent. Should she be treated like an average murderer or criminal?
You mean your cousin?
don't mean that.
Well, they may have to move her now because she's getting riled up.
Yeah, but we don't have. Randall, are you concerned about violence towards others in the room if
Well, no, I'm more concerned about the
her state of mind?
Decorum in the courtroom.
Sure.
So she's
Amanda, how do you feel about okay, how do you feel about excusing her presence? Her son has concerns about that, but if you'd like her here, I'm happy to just mute her and continue to have her here.
That's fine. I was going to introduce myself real quick. Miss Willie, my name is Amanda.
The officer did mute her.
Okay.
Officer Whitaker did mute her because she is becoming concerning. So Amanda, what say you?
That's fine. We can excuse her.
All right. Officer Whitaker, we can have her leave the room. All right. So Amanda, have you had an opportunity, and the court is doing this for officer safety. She has pending criminal charges in Washington County for battery on a nurse, 2 batteries on law enforcement. And I don't want to create a further bad situation here in Jackson County. Ms. Kelly is her attorney, has been appointed to represent her. Ms. Kelly, have you had an opportunity to review the file?
Briefly, Your Honor, I reviewed the evaluation that was done in Washington County, and I emailed the court and Ms. Jeffcoat yesterday, late yesterday evening.
I have not had an opportunity to review that email, but I'm happy for you to tell me what your thoughts are.
Okay, pretty much the extent of my thoughts is I'm not sure what to do with Ms. Pittman to get her the help that she needs quickly in terms of competency through criminal competency. It looks like there had been maybe a Marchman petition filed that was dismissed, and I agree this is probably not a Marchman situation, but a lot of times even when there are...
I think it was a Baker, and Randall filed it. He filed it late last week. I knew the criminal charges were coming, all attorneys were involved. Then in any event, I knew her criminal charges were coming, and we can't have a Baker with felony criminal charges pending, so.
Right. In the past, when I've had cases where there is someone who has dementia or some sort of issue like this and criminal charges, we've also had a concurrent incapacity adult guardianship case, excuse me, and sometimes it's easier to place them in care facility through that procedure than through competency, because I don't believe that DCS has the ability to place her in a nursing facility, and the order that we have so far doesn't lay out the factors that she is a danger to herself or the community, and the least restrictive means would be for her to be committed to DCF. So
you mean the evaluation versus the order?
Yes, I'm sorry, I misspoke. Yes.
Sure. I understand. So what are you asking for as it relates to competency? Are you asking for another evaluation?
That may, while she's there, we can go ahead and get her another one, and I'll try to get that set up and the paperwork to the court. But her family may want to speak to an attorney. I think I heard earlier that they are working with Mr. Roberts, so they may want to find out about filing adult guardianship and incapacity proceedings too.
Sure. I'll mention that to them, but also to be clear, Mr. Roberts is representing Randall Pittman as a public defender, not the family of Willie Ruth Pittman, but I'm happy to share those options with them as well. So I'm going to order that she be evaluated a second time. Now, I don't have very much concerns about the fact that the evaluation wasn't an in-person and basically was based on records, because she was unavailable for the evaluation. And in the past, we've moved forward with something along those lines. But I'm going to appoint Dorico, because I know Dorico will get out there this week to see her and get us an eval really quickly. Okay. Unless I hear any objections from the state or the defense.
No objection, Your Honor.
And then we'll have 2. Okay. In the interim, I do want to tell the family, I know you are concerned about this situation. If the family chooses to file guardianship paperwork and someone becomes her guardian.
Well, I intend to, Your Honor.
Okay, but Randall, this has been years coming, okay? This isn't the first time she's behaved this way. I'm just saying, no one has, but whoever does, I will absolutely consider what options we have about releasing to a guardian, releasing to a long-term care facility, I will do that, but no one has done that, and it has been years of very frequent law enforcement contact, and that is no longer something that this court will tolerate. And so we're going down the criminal justice route because the family has not gone through the guardianship proceedings. Okay?
I guess my question is, if she is incompetent, is that a no?
I have an evaluation that says she's incompetent now.
Well, I have about 6. I can get them for you. I mean,
I don't need to look at them because they're not my court ordered evaluations, but go ahead. What's your question?
I mean, there's no question she's incompetent. So
No question.
I'm just a little bit surprised.
The problem you might have, okay,
Yeah.
is that you are presently a criminal defendant and she's the victim. Okay. Now, I don't know what's going to happen with all that. I'm sure Mr. Rom, you've got great representation, so we'll figure out how that all plays out. But Judge Patterson, who is the guardianship judge, may or may not appoint you her guardian because you're a criminal defendant involving her as a victim. It may be somebody else, right? And Randall, let me tell you, and I'm going to say this on the record because I'd like Judge Patterson to know, quite frankly, I let you be her caregiver on the 20th. Law enforcement had contact with her on the 28th and the 29th, and you were nowhere to be around. And that's okay. I mean, I guess that is what it is. I don't know that you can care for her 24/7, right? I think she needs to be in a facility based on the way she behaves vis-a-vis others, okay? But releasing her to your care from the 20th to the 28th, 29th, when all this went down, she was in your care and you weren't able to control her, I guess is the better way for me to put it, right? So I want everyone to...
I object to that on the record, Your Honor.
Okay.
I think I can take
Fair
care
enough.
of my mother.
Fair enough. I want everyone to know that I think we're beyond just letting her go back home with you guys, okay? Because she needs specialized care. Yes, very quickly, go ahead.
Is she getting her proper medication
We're hopeful.
in the jail?
Yes, that's the hope.
And is the doctor in?
Well, they can't even get her a urinalysis in the jail, so
won't get her
they
to
can't do anything for her in there. She's been diagnosed with a UTI. It's been, 3 or 4 days, and they haven't even gotten a urinalysis test.
What, can we have her examined for whether or not she has a UTI, please? Yeah, have the nurses evaluate.
They say one thing, but the nurses tell me something else.
Randall, tell me this. You're not charged with the other. Where were you on the 28th and 29th when law enforcement had contact?
She does not have an order saying that she needs 24-hour care.
I understand, but
I have to, before I've had to watch my granddad who's 96. My dad,
is your granddaddy still living?
No, he's not. But I'm just
so
telling
I'm
you
talking
life
about
of
the
Grandma
28th and 29th.
Well, actually, I was up here filing the Baker Act paperwork the one day.
Yep, I remember that morning.
And the other day, I was probably at the grocery store somewhere. Somebody has it. I mean, I don't get much help around there, but I don't ask for it. I'm a one-man show, and I don't care. That's my mother. I'm gonna fight to the very end.
Randall, she spit on an officer and hit another one in that time.
That's the job they sign up for, Your Honor.
No, sir. That is not
do
the
sign
job
up
law
for that.
enforcement
There's
signs
other
up
things
for.
they can go out and be a pro basketball player or a hockey player, whatever they want to do. If they don't want to deal with that, but that's the job they signed up for.
So listen, family, if someone files guardianship paperwork and Patterson appoints a guardian and there's a plan in place, the court may consider some sort of release associated with that. But right now she's held without bond because she's violated her release on her Washington County case, and she's got a $100,000 bond on the current charges. Does anyone have any other additional questions at this time?
Yes. Number one, her bank is not honoring the power of attorney.
Talk to an attorney. That is not for me to advise you on.
Well, I know how to sue them. I'm going to do
Okay.
that. But I thought maybe the court would do the just thing by ordering them to release her funds.
Absolutely not. The validity of the power of attorney that she has issued you is not before this criminal court, and so I will not take any action on that matter.
Okay, well, I'll just sue them.
Okay. Do you have any other questions?
No, I don't, Your Honor.
Ma'am?
Well, yeah, I have one more question.
Go ahead.
I guess it was a few weeks ago, the officers came out to my house, and I had someone over there cleaning up, and I have 2 phones. I gave him one, and he dropped my phone because I told him that that I had no contact order. And when the cop showed up, I guess he freaked out and ran and dropped my phone. The officers picked up my phone. They had it on their camcorder, but my phone is nowhere to be found. I'm just asking the court, to see if you can somehow give me my phone, because I have very important information on my phone.
So if you think law enforcement has the phone, was it the Jackson County Sheriff's Office?
Yes, it was.
Then if law enforcement took it, it doesn't sound like they did, because if there was no charge at the time, they wouldn't take something into evidence. But if they did, they would have put it in an evidence with the evidence custodian. So you may check with the evidence custodian.
I've already checked with them.
And it's not there.
No, it's
so
not
they
there.
don't have it. I don't know what else to tell you about that.
I understand that, Your Honor.
Okay. Ma'am, do you have any questions?
These are my sister's twins.
Yes, ma'am.
Reg and Randy.
Yeah.
And I know I'm, really, I confide in especially Randy's attitude about everything, because I don't have all the information. I just love my sister and I want the best for her and everything. And Randy, when he's away, he's...
Ma'am, do you have a question for the court? I have a lot of cases on the docket this morning.
Yes, ma'am.
Yeah.
I have a question. If things turns out that Randall cannot be guardianship, I live in Orlando, but I'm willing to be the next person considered for guardianship.
I think you should tell that to whatever attorney you guys retain to file for guardianship paperwork. You have to do it through an attorney, okay? You can't file for guardianship without having a licensed attorney. So whoever you guys retain for that, talk to them, and they will know that there's multiple options for guardianship. And that's important, because that gives the court options. Okay?
And one more thing.
Yes, ma'am.
I tell you, not ask. Randy he's really trying hard to get his mother in a place that's understands and can treat her behavior positively, accurately and everything. And so he's Geneva, he's pointed out a couple of places, Pensacola, that he wants to try to place her, with these particular behavior problems. It seems like a lot of those facilities, when they see that she's a little aggressive or whatever, they want to send her back home.
Understood.
But we want a place that's, really able to treat her disability.
So would the court. And let me say this, even if you don't have guardianship, if you find placement at a safe facility, I may consider releasing her bond revocation and releasing her to that facility if you have a place. The person you talk to about that is Miss Amanda Kelly, who is her attorney, and she will bring it to me and she'll tell me, Judge, we've got a place for her. If that happens tomorrow, I will release her tomorrow. But it's got to be somewhere where she is safe, doesn't hurt herself and doesn't hurt others. So if you guys find it, great, we'll do it. Okay?
Very good. And
Yes,
Miss Kelly, may I have
Her name
Yes,
is Amanda Kelly. And Lindsay, would you mind writing something down for sister? Do you want a paper here?
May I have a...
She's going to write it down for you. Here, Lindsay.
Thank you.
Yeah.
And
so
I'm gonna
Amanda, if
give
you'll give us
y'all-
your contact info.
Okay. Yeah, this is going to be my office cell phone. I'll be physically out of the office today, tomorrow, and Thursday, but you can reach me on the cell phone number. It's 850 and then my email is Amanda. Lowercase c.
Amanda, is it ORCC1 or just O?
All right. Well, I think we've got the idea, and they just keep making me mute them. So let's go to Judge Boyd. Say good morning to her.
Act for any
Morning.
place.
Are you all ready to proceed on the motion to revoke? Yes, ma'am. All right, this is Criminal Trial Division. It's a motion to revoke. All right, the court is calling 2023 CR 11289, State versus Jorge Sandoval. Can I have parties announce?
Jason Garahan for the state, Your Honor. Robert Robach for Adaman. For Sandoval.
And are you Mr. Jorge Sandoval?
Yes, Judge.
Did you review the documents entitled Motion to Revoke Community Supervision and State's Motion to Supplement pending motion to revoke probation with your attorney? Did you understand it?
Yes, Judge.
Are you the same Jorge Sandoval who was placed on community supervision in 2023 CR 11289 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on January 30th, 2024 for a term of 5 years? Is that you?
Yes, Judge.
All right, state.
Yes, Your Honor. Violated condition number 1 on or about the 12th day of November 2024 in Medina County, Texas. The defendant Jorge Sandoval committed the offense of evading arrest or detention with a vehicle in violation condition number 1.
How do you plead to that? True or not true?
True, Your Honor. Your Honor, we'll waive the remaining violated conditions.
Any objections to the waiver?
No objection.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 5 years in the prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, and it is to revoke the individual officer's probation and to reform the underlying sentence to 2 years in the Texas Department of Corrections.
All right, thank you. And are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, has he done anything on probation? Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Jorge Sandoval.
All right, have you done anything on probation?
I completed the Saturday, I completed the aftercare program. My UAs were clean. Reason I wasn't reporting because I was incarcerated for 6 months
Mhm.
and I got extradited here for the MTR.
Well, I mean, that doesn't have anything to do with the evading arrest, detention in a vehicle. So at some point you were not incarcerated, you were evading the police in a vehicle. So other than going to SADF, which if the court ordered you in an inpatient treatment, you had no choice. So you're a captive audience at SADF. So other than SADF, did you do anything else?
Work.
Probation?
Judge, Mr. Sandoval completed the SADA inpatient treatment. However, the aftercare was, there was the violation of program. He did complete the intensive outpatient treatment. And out of the 100 hours of community service, he has a balance of 23 hours.
All right, so what was the issue with the aftercare with SADA?
I'll have to look in his file, more extensively. Just give me one minute.
What was the issue with your aftercare in SADA?
Actually, with the community service, I completed all of it.
No, I'm talking about SADA. You had to go in inpatient for drug treatment. Then they have an aftercare program. So my question is, with the aftercare program, why did you not successfully complete that?
Oh, I finished it
No, the report from probation is there was an issue with aftercare.
because I got incarcerated and that's why I couldn't report no more.
Okay. And what were you incarcerated for?
For
The evading?
Yes, ma'am.
So you didn't successfully complete aftercare because you
did
picked up new
successfully.
charges. Why are you picking up new charges? I don't understand.
Actually,
Mhm.
Judge, he has been in for over 245 days. No, it's 580 days.
The violation of the new event was why he was exited from the aftercare.
All right, this is what the court is going to do. The court is going to revoke. The court is going to sentence you to 3 years in the prison, give you credit for any time served, and the court will request the therapeutic community. The therapeutic community doesn't increase the time that you're in custody, but they are there to hopefully help you become a better citizen and to help you maintain your sobriety. when you're released from prison, if for some reason you can't find a place to go that can help you maintain your sobriety, if you come back here, I'll pick up the phone and call somebody. You understand? To help you. Did you?
What do you mean, like, place of sobriety?
To help you maintain your sobriety, because obviously you still have drug issues.
Well, I'm planning on leaving the state.
Oh, okay, then. Well, somebody there will probably be able to help you. And I wish you the best whatever state you choose to live in.
Thank you, Your Honor.
All right, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, you have a limited right to appeal. And that right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, and I'll give you credit for any successful completion of inpatient treatment. All right, is there anything else?
Nothing, Your Honor.
All right, and I don't think, we're off the record, I don't believe any of the new number ones are here in Bear County, is that correct?
No, Your Honor.
They're all Medina?
They're all.
So you'll have to see about those cases if you have not taken care of them there.
Yes, Your Honor.
All right, good luck to you, okay?
Thank you.
You're welcome.
Thank you, Judge.
Hey, channel members, if you weren't able to make this morning's pre-show, after we're done here, you should go back and watch it. We covered a bunch of things, but one of them was a rather corrupt judge here in the United States that we took a quick look at, so you should go check that out. If you're not a channel member, if you're one of those people who are subscribed but kind of lurk in the background, I encourage you to go ahead and become one. In the pinned chat, you'll find a link for that. It's worth it. We have a lot of fun, especially on the pre-show, but you get other benefits as well. So give that a look. Let's go to the east, to Judge West. East to west.
Mr. Harmon, in cause number 24, DCCR 1612, you are charged with the second-degree felony offense of assault of a peace officer from July 9th of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, sir.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Speak up.
Yes, sir.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Harmon is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. And that'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what's the state's position with regard to bond?
I do have one concern, Your Honor. The call where this happened was a family violence choking incident. He was charged, I believe, with family violence burglary with intent to commit assault. Those cases were not pursued by the complainant, so they're not pending or anything. But if he gets released, I just want some kind of safeguards in place.
Well, they didn't file the cases, and then I don't know that I can. Where are you gonna live when you get out, Mr. Harmon?
I was living with some people that was just friends with.
I cannot understand
I was
you.
living with some people that was just friends with.
Right.
And my mother, so that's why I was going back to.
But that's where all this happened?
No.
No, this is a different place. Okay. So if I let you out today, I want to, what's the name of the friends that you're saying that you're gonna live with?
Arlie Woods.
Say it again.
Arlie Woods.
Arlie,
Arlie Woods.
Iron, how you spell it?
Spell first name.
IRAN.
Gotcha. Last name Woods? Okay. So at least while this is pending, if I let you out today, I'm ordering that you live with them and not at the other place where all of this happened. Okay? Maybe later, if everything's going well and you want to have some relationship with whoever this was, I'll get more information about that in that pre-sentence report, and we can talk about it at sentencing. But what I'm going to do today, because of your plea for probation, is I'm going to reduce your bond in your case to $1,000. So if you're able to make that bond, there's a couple of things that are very important. The first thing is that if you make the bond, you go directly to the probation department so they can start that interview process for your pre-sentence report. If you don't go there and do that, then you run the risk of me not accepting this plea agreement and things could be much worse. You understand? Also, a condition of that bond is that you are going to live with Iron Woods. No one else until either I give you permission or we discuss it again. You understand? Also, if you are arrested for anything, if you make that bond and you're arrested for anything before you come back for sentencing, obviously things could go. I don't have to accept this agreement. Okay? All right. See you at sentencing.
Thank you.
Thank you, Mr. Nichols. Okay. IRAN.
So yeah, as Bailey pointed out in the chat just a few minutes ago, the show opened up today with a rather spicy hearing in Judge Middleton's court of all places. We don't often use the term spicy with regards to Judge Middleton, but he was hot and for good reason. And it's definitely worth a look. So at the end of this, you have two choices. You can either rewind to the beginning if you haven't seen it and check that out, or if you wait a little bit, it will also post as a separate video today, maybe a separate several videos, because there was a lot going on there. But it's the most animated, I would say, I have seen Judge Middleton maybe in ever. Let's hang here for a minute. Looks like she's bringing somebody else up.
Not relapse.
That's the agreement? Okay, so we'll just go through the motion and then I'll mark that, and if that's the agreement, we can get that paperwork done. Let me go ahead and get it pulled up.
Judge, I'll tell you, she pretty much got put on probation, reported once or twice, and dropped off the face of the earth for a few months. But she's, based on her previous PSI, she's doesn't have a stable place to live and drug and mental problems, so that's why we do it.
I'm gonna extend it. 5 deferred on the ag robbery. So
Honest ag robbery of everything, but not you. That's
just
probably a good
just
idea
to
because
take
of
up
this
at least a
situation.
year or so, just to take up for the year that she didn't go.
There was interesting fact pattern in the original case.
Okay,
Goes back to her other root problems.
gotcha.
Drug use.
Good morning. Are you Katrina Swan?
Yes, ma'am.
And Ms. Swan, the best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. And Ms. Holmes, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Swan, in cause number 24, DCCR 1362, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 29th of 2024, and that was for the offense of aggravated robbery, and that was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed for the months of January, February, and March of 2025. And is that Count 2 alleges that you failed to never become intoxicated or under the influence of any intoxicating substance, and that you admitted to using cocaine and alcohol on January 7th of 2025. And is that true or not true? Count 3 alleges that you failed to participate in the mental health services and follow all recommendations of that. Is that true or not true? Count 5 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? Count 6 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy program. Is that true or not true? True. And then count 7 alleges that you're behind in your court-assessed fees. And is that true or not true? All right, did you enter your pleas of true to counts 1 through 7 freely and voluntarily?
Yes.
And did you plead true to those counts because they're all actually true? Yes. All right, then I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily, find those counts true, find sufficient evidence to find you guilty and revoke your probation. But it's my understanding that the probation department and the state are willing to give you a chance today to go to the special needs Safe P program, which will help you hopefully get all of these issues behind you, learn how to make better decisions, stop using drugs, get the mental health treatment you need so that you can be successful on this probation. I want to make sure you understand that this is your second chance now, and you will not get a third. You are on probation for a first-degree felony. Today, right now, I could send you to prison for the rest of your life. The rest of your life, from 5 years up to 50, 60, 70, the rest of your life for violating probation on this type of offense. So you need to take advantage of everything that they teach you, because when you get out of Safe P, you'll have aftercare, you'll have people to help you, find places to live and all of that. But it's going to be up to you to take advantage of those things. Do you understand?
Yes, ma'am.
All right. I'm also going to, because you didn't report and because this is going to take some time, I'm also going to extend your probation for a period of 2 years. So you're now on a 7-year probation instead of a 5-year probation. Now, every single person who's on probation in my court and any court can get off their probations early if they do everything they're supposed to. So it doesn't have to be 7 years, but it would take you getting everything in line real quick and doing everything right. Do you understand?
Yes, ma'am.
All right, good luck to you, ma'am. You can go back with the bailiff. They're going to get some paperwork for you to sign about safety. You need to sign that when they get it to you.
Thank you, Your Honor.
Thank you.
Let's continue the ping-ponging around Texas, and we'll go back to Judge Boyd.
All right, so you have a motion for a bond.
That's correct, Your Honor.
Has the bond been set or no?
He's currently remanded without bond. I did file just this morning a motion for PR bond because I did associate that with the newly indicted case. And I did file this writ as a result of going over the 90 days without indictment. We're currently at the 111th day. And as per Odyssey court records, the matter was indicted yesterday. And I know that as per 17.151, the initial burden is on the state to make a prima facie showing that the case was indicted within the 90 days. And I don't believe that has been done.
All right. Was the case indicted within the 90 days?
No.
All right. And so what are you requesting before we go on the record?
A PR bond, Your Honor. My client is indigent. He can't make really any.
Okay, all right. So we'll go on the record. I'm just trying to figure out what's happening. So you requested a PR bond. The state has already said they didn't indict within 90 days. All right, court is calling 2025 CR 00. Oh, before I go on the record, have you had a chance to review the state's file?
Regarding the newly filed case?
Is there another case other than the unauthorized use of vehicle?
Felony, no, ma'am. He has a couple of misdemeanors.
All right, have you had a chance to confer with the state on this?
Not on this, Judge, because I did see some preliminary offense reports, but the matter just did get indicted yesterday.
What do you have in your file? Or you reviewed the state's file?
Well, the thing is, Judge, that I'm kind of pressed for time this morning. That's why I came here early to get this hearing before the court. And then I was going to request the PR bond also because I need time to review that discovery with my client, the videos. and all the reports. And since this matter just got indicted, that really triggered me to see about going upon my client's defense, knowing that the state was finally going to move on his case. So
Right, and you have all of the videos, correct?
I have no idea. It just says it just got indicted yesterday, Judge. I have not been able to look into that. My efforts have been focused on the writ.
All right, does anybody know what his criminal history is?
Locally, yes.
All right, let me see.
PG 1 1 to 4, for which he was sentenced. A felon possessed firearms. And seems as though it was dismissed. Give me a moment to check on that, Judge.
Okay.
That was dismissed.
All right, so what is his NC?
Authorized use of a motor vehicle for which he was sentenced.
Does he have any out-of-state history?
Don't know, Judge.
Can you run that to see if he has out-of-state history?
I cannot. I can ask our investigator to run it.
All right, if you have the investigator run that.
Never lived in English. Your Honor, would it suffice if my client under oath testified as to his potential out-of-state record? He's saying he never lived out of state, has no offenses anywhere out of state.
Okay, and I'm looking on my system too, but the system is running slow. All right, the court is calling 2025 CR 006612 State versus Luis Antonio Gandaria.
Yeah.
Sorry, Junior. Could I have parties announced?
Andrew Harris, Settlement for the state. Renee Munoz on behalf of Mr. Gandaria.
And are you Mr. Gandaria?
Yes.
Right. Counsel, you've filed a motion for a bond. And off the record, both parties agreed that your client had not been indicted within the 90-day time period. So what are you asking for, counsel?
We're respectfully asking for a personal recognizance bond. My client has been in custody for the last 111 days, not able to make bond. He does not have any kind of resources in terms of having a job or employment to make bond, as well as friends and family are limited, that they will not be able to have him make a sufficiently bond if reduced. That's for the foregoing reasons why we're requesting a motion for personal recognizance bond due to and using the mechanism of the 17.15 writ that was shown to be in violation of in this instance.
All right, do you want to call your client with regards to the amount of bond he's able to make?
Yes, Your Honor.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? Yes. All right, you can lower your hand, state your name for the record.
Luis Antonio Gandaria Jr.
All right, you're gonna need to slow it down because the court reporter has to take everything down. And if you'll speak up so the court reporter can hear and so I can hear. All right, defense, you may proceed.
Thank you, Your Honor. Mr. Gandaria, are you currently in custody at the Bexar County Jail? Yes. Okay. And how long have you been in custody there? I've been locked up since November 9th. Okay. Then you got out and then you've been in custody since February, is that correct? Yes. Okay. At this time, are you currently employed? No. Do you currently have any amount of savings that would allow you to make a bond if the bond were set at a certain amount? No. Okay. Do you have any family or friends that would be able to assist you in making a bond that the court may set? I don't have a debt. I only have a mom.
Okay, so you need to speak up. And I know you're speaking towards him, but
I only have a dad. I don't have a dad. I have a mom. Okay. And it's all mom. Okay. And then your mom, is she employed? Yes, but she only how much? Oh, so she makes a little money to sustain herself and her household. Okay. Have you lived or resided anywhere outside the state of Texas? No. Okay. Do you have any criminal history outside of the state of Texas? I do not. Are you swearing that under oath today for the court? Swearing under oath. I don't have any warrants or been out of Texas anywhere. If you are able to make bond, would you attend all court sessions as required? I will. Would you follow conditions of bond if the court were to set them? I will. If the court required you to check in with the pretrial officer, would you check in with that office as required?
Well,
Those for the questions, Judge.
All right, any questions?
a few. I want to make sure that I understand this correctly, Mr. Gandaria. You were originally arrested on September 27th, 2024, correct?
Yes.
And you were released pending that court appearance?
Yes.
And subsequent to that, you were arrested and charged with the offenses of evading arrest and the instant offense unauthorized use of a vehicle, correct?
Yes.
So you are still pending trial for the September 27th, 2024 offense, is that correct?
Yes.
Thank you.
Just a couple follow-ups, Judge. Regarding those offenses that the prosecutor listed, have you been found guilty beyond a reasonable doubt as to any of those offenses?
No.
Okay. Look for the questions, Judge.
All right. I do have some questions of him, but I have some procedural questions. So with regards to the cases, the evading arrest, detention, and the burglary of the vehicle, were those cases alleged to have been committed before or after this case?
The burglary of the vehicle, as far as I'm aware,
Mhm.
occurred prior to the instant offense. The evading arrest arises out of the same criminal episode.
All right.
As far as I can determine.
All right, so then my next procedural question, with regards to the burglary of the vehicle. I'm assuming he had that case pending, then he bonded out. And then that's when he's alleged to have committed unauthorized use of a vehicle and evading arrest, detention.
Yes, Your Honor. Thank you for understanding the timeline.
All right. Now I have a question for you.
Yes.
Have you ever had any type of mental health diagnosis or been on any type of medication for mental health issues?
When I was younger, I was bipolar, so bipolar.
All right. Everyone, we're on the record. Then my other question for you is, have you ever had any type of drug use in the past?
Like growing up, yeah.
All right. And what would that be?
Weed.
Anything other than weed?
I mean,
Everyone, we're on the record. Please stop talking to the right of me because I'm trying to concentrate on what they're saying. Yes. So other than the weed?
I messed around with meth, but not so much
How long has that been?
in years.
Years? How many years?
5,
All right. Any other questions?
not from the state.
All right.
Nothing.
So defense, I know that you're requesting a PR bond state.
17.151 speaks of at least one of two alternatives: release on a personal bond or by reducing the amount of bail required. So it seems to me that considering Mr. Gandaria's recent criminal history, release on a personal bond does not seem wise. His current bond is set at $5,000. Considering the relative paucity of information provided by the defendant, for instance, that he has not actually brought in any other witnesses to testify to their financial circumstances to substantiate his lack of ability to make bond, the state recommends a reduction to $2,500.
Your Honor, in response to that, 17.151 does not state that a PR bond is triggered or a reduction is triggered because of, with respect to criminal history, severity of offense, the bottom line boils down issue is the state did not move on this in a timely fashion. And this has caused myself as defense counsel to now just at the 110th day have access to these things, which slows down the court, slows down the judicial process. Relative to this, the violation of 17.15 has been shown. Thus, it's triggered for the court, obviously, to determine if the PR bond is whether to be granted or not. And my client testified, believe honestly, that he can't make any kind of substantial sum to a bond. And because he's been in custody with 110 days and hasn't bonded out, also further represented by the Bexar County Public Defender's Office, has been shown to be indigent. That's why he was appointed to the Bexar County's the Public Defender's Office to begin with. That we're asking for a PR bond to be granted, so he has the chance to prepare for his defense, not in custody, and it's not any fault of his. These are just allegations. Nothing has been proven beyond a reasonable doubt. And he's been waiting patiently for the opportunity to defend himself of this charge, which has just arose in terms of a formal indictment yesterday. So for those foregoing reasons, Judge, we're respectfully requesting a PR bond that will lead to the efficiency of this case being resolved and his constitutional rights being intact due to a lack of timeliness on the state to indict his case.
May I make one further remark, Your Honor?
Yes.
It seems to me that perhaps 17.151 is not applicable in this case to begin with, because Section 2 of that article provides that the provisions of this article do not apply to a defendant who is, subsection 2, being detained pending trial with another accusation against the defendant as to which the applicable period has not yet elapsed. And that seems to be the case in cause number 2025 CC 002343, for which the defendant was taken into custody, as far as I can tell, on February 12th of 2025, and information was timely filed, and he is pending trial on that accusation.
All right, and that's why I was asking the parties, the legal process as far as the time. All right, this is what the court is going to do. The court is gonna grant the PR bond. I'm gonna set your bond at $5,000, grant a PR bond. I'll ask that the fees be waived. There's to be no driving. There's to be regular UAs, a referral to Center for Healthcare Services just based upon what he said about his previous mental health. Any other conditions state you will request?
Partial GPS tracking, Judge.
We'd oppose that, Your Honor. If he's going to be going to regularly UAs and referral for CHCS appointments, we would request as limited movement to curtail him trying to get himself into services and treatments. He has this case as well as the misdemeanor cases. He would still need to make a bond on or have a judge rule on that. And he's already agreed to make all appointments as required and show up to court as required. He's been in custody the last 3 months, so I think he can kind of do something more. And obviously there, he's not, with the understanding that he's not going to be let out because his case has already been indicted. But since just the indictment just happened yesterday, we're requesting that he be allowed leave to attend some of these appointments to get to the root cause of what may be causing him to enter the criminal justice system.
All right, and the court will note for the record that the court does not, and I've done the research, the court does not see any violent history in his past that would warrant GPS. But I do know that there is an issue with him driving vehicles that do not belong to him. And I'm basing that upon the indictment where you've been previously convicted of unauthorized use of a vehicle. So the court's conditions will stand. Ms. Ferguson, on this case, I need a 30-day reset. And that is going to be a plea deadline date. You all will need to confer off docket.
Yes, Your Honor, we'll review that discovery in a timely fashion and we'll be here ready for court.
Can we not do it that week?
I might have some July 4th plans one week myself, Judge.
Yeah, that's why I was like, maybe people will have plans. All right, it's going to be July 10th. Ms. Ferguson, if you'll give him a reset form, thanks.
Thank you. Thank you, Your Honor. We'll get that done.
All right, I've had my eyes on a lot of different courts as I always do, but honestly, the most hectic place, the busiest place this morning has been the Pardon and Parole Board in Louisiana. They've been working through them. So let's check out one of those.
Yes, sir. Good morning. And we're here for a revocation hearing. And what is your DOC number? 581376. Okay, that's correct. And do you have a waiver form in front of you that you signed? Yes, sir. Okay, and that's your signature on there. Yes, sir. Okay, and you are currently at Ouachita Correctional Center, correct? Yes, sir. Is there anybody in the staff with Ouachita here in the room? Would you tell us your name, please, sir?
Good morning, it's Deputy Marchand.
Okay, thank you, sir, for hosting us. And I see a gentleman seated next to you, and what is his name? Or, sir, what is your name?
My name is John Roa, that's R-O-A. I'm a appointed attorney.
Okay, you're appointed attorney,
Yes,
okay?
that's correct.
All right, thank you, sir. Well, the way that we conduct these hearings, and of course, I think you can see our name tags of who we are, so we won't go through the formalities of all of that. But we're in Baton Rouge at headquarters, and we assign one of these, each one of us is assigned as the primary interviewer, but we're all familiar with the case and have read a lot of things about it. And so your particular case has been assigned to Mr. Freeman. So Pete Freeman will go over the rule violations that you're accused of violating and ask any questions, and we will, and then we'll vote. Okay, so Mr. Freeman?
Okay, Mr. Minor, it is alleged that you engaged in criminal activity on or about 12/26/2024 when you committed the offenses of domestic abuse, battery, disturbing the peace by fighting, interfering with emergency communication, and a warrant for contempt of court. On 3/30/25, you pled guilty to the amended charges of disturbing the peace and interfering with emergency communication. You were sentenced to serve 90 days in the Ouachita Parish Jail with credit for time served from January 7th, 2025. And how do you plead to that charge?
Plead guilty to disturbing the peace.
All right. We'll get in, I'll ask you some questions later, so we'll get into that more. And then your other violation is that you failed to pay supervision fees for the month of October through March. You are currently $378 in arrears. How do you plead to that charge?
I plead guilty.
Okay, Mr. Minor, first off, you have some people here that want to speak on your behalf. So first, we're going to hear from Ms. Morrison.
Yes, I'm his mother.
Okay, what do you want us to know about him, Ms. Morrison?
Okay, for his parole, paying the fees, he was trying to get himself together, but like I told him, he got to pay something. I don't care what it is. If it's $50 a month, $25 a month, give y'all something, because it got to be paid on that part.
Okay.
And for the other charges, okay, the warrant that he had, the warrant should have never been on him, for one thing, because he did time on that warrant, which what the judge's name is, Tammy Lee did see that. That's why she just dismissed that charge. Okay. And on the new charge that he did take, and he pleaded guilty to what, simple battery or something, or disturbing the peace.
Yes, ma'am.
I told him, don't plead the guilty. Get it over with. You got to get out here. Like I told him, for one thing, when if he beats release, I'm gonna take him to go get his medication. My son been taking medication at the age of 5 years old. They would not let him come to school without his medication. He does take medication. I'm gonna get his medication for him. Make sure he take his medication. He's gonna be living with me. I'm gonna help, and I still got his job lined up for him, so it would be no reason you save your money up, but pay that parole board. You give them what they need or what you're supposed to pay. Save the rest of your money up, because I'm gonna help them get them another apartment.
Okay, thank you. Ms. Sutton, is that you, Ms. Sutton?
Yes, that's I.
Okay, what do you have to say?
Yes, so it seems that when we had our disagreement, our argument the night of, he seemed like he was under a lot of stress. And I know that I was under a lot of stress, and we were trying to keep up with paying the bills for our apartment. And when he got out of prison, he got his apartment for us very fast. And I think that that's commendable on his part. And he has shown signs of growing as a person, but he's just been having some trouble regulating his emotions from the stress. And I know that I have schizoaffective disorder, and this affects my ability to process different things and to handle high levels of stress. But I think he might be diagnosed with some of the same things that I have because he's on the same medications that I take.
All right, Ms. Sutton, may I ask you this, Ms. Sutton, did he hit you?
No,
Yeah, you're not lying to me.
that was fabricated.
That was fabricated.
No, that was fabricated.
So he didn't hit you with his fist. Well, why did he throw your phone?
No, sir. The phone, he didn't destroy my phone neither. That's what I was trying to tell to the people. I had wrote a statement. That's what I was trying to tell them. But my phone was destroyed by somebody else. And this person was a neighbor of ours. And they was getting into our business. And I told them, I want you to stay away from our house because you're causing too many problems. You know. And I've just been trying to get this situation under control and everything.
Okay. All right, let's go back to you, Mr. Minor. You tell me what happened that evening with the fight. I'm not that worried about the fees. I'm more worried about the other charges. So what happened?
It was just an argument between me and my fiance, and I used to have company come over. I'm be honest, I had company come over. I'm be honest, I got caught, cheating. I'm be honest with you, I ain't gonna sugarcoat. I got caught cheating, and it get led to an argument between me and her. You feel me? And we just wanted everybody to stay away from our apartment and everything, stuff like that. Like I said, I was stressed out a lot. I wasn't taking my medicine. Now I'm back on my medicine. Since I've been incarcerated, I'm back on my medicine and everything, take my medicine. And, it gets a little stress. It wasn't nothing physical. You hear me? I did not put my hands on or nothing, sir. I get did too much time to be out there breaking the law. I'm gonna be honest with you, sir.
Okay. So you did plead guilty to disturbing the peace. Why did you plead guilty to interfering with the emergency communication? Your lawyer can help you out with that if you want.
Well, I was not part of taking that plea at that time. But his mother just said that she told him to do that. I don't know why. I would never advise that. But I think he wanted to get it behind him. I mean, because these were misdemeanors. Disturbing the peace is probably more what happened than a domestic abuse battery from what everyone is saying. I do want to note that the protective order was dissolved prior to his taking the plea, and then the charge was reduced by the assistant district attorney. I do know that he was ordered when he was first sent to 72-hour hearing for the charges that we're talking about. The judge ordered him to see a physician about his medication. And he had to do it like within 72 hours. He did. He went to a mental health facility, got his meds, and he's on his meds right now. They're giving them to him here at the correctional center. And he's a different person. I mean, he's calm. He's in control of himself when he's on those meds. And so he is, like his mother said, the job is still open for him.
Right.
All these months, they're still keeping it open for him. And the protective order was completely dissolved by the judge over the case. And he and his fiance are still planning to be together. So I think all these factors tend to favor his release on parole. I mean, he's also done the majority of the time. I think it's something like 12 and a half years of a 15-year sentence that he's already done. So it's not like he's just started the sentence. This is, the majority of it he's done already. And I would just request that you look hard at granting him parole for this. And so let him get back to his life that I think he's got set up now.
Was that protective order in place when these charges were filed?
No, that was issued for those charges after he was arrested.
For those charges. So when was the protective order for? It was against this victim?
Yes.
Yeah.
Was the protective order there when you got out of prison?
No, sir.
Okay, it was gone by then?
No, it was on this charge right here. The new charge they gave me.
Okay, that's
Said
when
I
the judge
did.
told you had to stay away. Okay. Okay.
I have it right here, sir. The protective order, trying to see the date that it was put on. I have the date. Oh, it was, the protective order was put on him on December 27th, 2024. I think that was a day or two after he was arrested, because he was, I think, arrested on Christmas Day. And in February of this year, it was dissolved by the judge.
Okay. I have no further questions.
Full-time date.
Full-term date is 1/30/27, and he's been in for what, how long? 6 months now?
Yes, sir.
6 months on this charge, so that'll give him 6 months off there. Thank you. No questions.
Okay, you ready to vote?
Okay, Mr. Minor, problem is you did plead guilty. You know, people keep thinking that they can plead to misdemeanors and it's not going to affect them, but that's not true. So, you pled guilty to disturbing the peace and interfering with a communication officer. I found you guilty of violating condition number 4. I order that your parole be revoked and that you hopefully be sent to a DOC facility and get your mental health meds back correct.
Excuse me, sir.
Okay, wait, we're voting right now. Let's finish the voting.
I concur with Mr. Freeman.
Okay, and it just takes 2 votes, 2 of the 3 on revocation, but I concur also, which makes 3 out of 3. So I'm sorry to tell you, but at 10:38 this morning, your parole has been officially revoked. And we appreciate that. End this hearing at 10:38.
Alrighty, not necessarily surprising, I suppose. Let's finish our day off with Judge Boyd.
State versus Roxanne Marie Hayes. Could I have parties announced?
Andrew Harris Sandelman for the state.
Sean Sheffield for defending. We're ready.
And are you Ms. Hayes?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Probation, this is an application. Ms. Hayes, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, waiving count 1, proceeding on count 2.
No objection.
Did you review the admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
In count 2, you're charged with the offense of possession of a controlled substance, penalty group 1. 1 grams to 4 grams as a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
She has to sign. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Hayes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. They're asking that your punishment be assessed at a $2,000 fine. They're recommending deferred adjudication, and they're asking for restitution to SAPD for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense in count 2, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Should be contained in Exhibit 1 and attachments, Judge.
No objection, Your Honor.
State, you may be excused.
Thank you.
Did you review the document entitled waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and laboratory reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we just asked the court to follow his recommendation.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
16 and 11.
Who do they live with?
Me.
Are you employed?
Yes, ma'am.
What do you do?
Right now I'm doing Lyft, but I used to work for CPS.
I'm sorry, what?
CPS.
What is
Energy.
CPS? Oh, CPS Energy. If you're drug tested today, what are the results going to be?
Clean.
All right, when's the last time you used?
About 5 years ago.
I'm sorry, what?
5 years ago.
All right, this case is not from 5 years ago.
Your Honor, that it was not for her consumption regarding the drug.
All right, so I don't even understand. Is Child Protective Services involved?
No, Your Honor.
I don't understand why not. So I have concerns, and these are my concerns. She has a 16-year-old and 11-year-old living with her. And according to what I'm reading in the police report, she was dealing, and the car is smelling of marijuana, and then the car has license plates that don't belong to the vehicle. It comes back as a different vehicle. Then she has this person who's with her. Who is that?
My husband.
All right, then, so you have her husband who's involved in all of this, and they have a 16-year-old and an 11-year-old at their home. That's an issue.
I understand, Judge. As you can see, this is a little older case. This isn't just from a month ago or a couple months ago. I do not believe she has any priors. I believe there was a prior charge, but it was dismissed. This was a one-time thing, Judge, and she has been
on the straight and narrow since then, and even prior to that, Your Honor, she has.
All right, so let me just tell you what's gonna happen. I'm gonna follow your agreement, but I'm gonna have you drug tested today. If that test comes back as positive, then she's going into the Bear County Jail to be transferred for inpatient treatment. Okay. All right, probation. On this case, this is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. I'm going to want field visits 1 time per month until further notice. Please tell probation to check on the children. There's to be regular reporting by Zoom or in person, regular random UAs. Do you have your driver's license or identification with you?
Yes.
Okay. There's going to be a $2,000 fine. That will be probated.
Thank you, Judge.
Restitution to SAPD for drug testing. There's going to be 200 hours of community service restitution. I'm going to require that she completes parenting classes. Once that's completed, the community service hours will be deemed satisfied. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. And with regards to the no employment with minors, that includes if somebody wants her to babysit, you're not allowed to babysit. There's to be a TAP evaluation out of custody, follow recommendations. And I'm going to ask for a UA today. So once probation goes over your conditions, you're going to leave directly from here and go and obtain your UA. Okay. Probation, is there anything else? Yes. All right, is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And I just have a question for myself. We can go off the record. So where were your children during this entire, at home alone?
No, with my parents. My parents live with me.
All right, so now I know who's raising the children.
Oh, no.
Okay. Well, I mean, you were not doing it that night.
It was one night.
But you, according to the police report, you all were smoking marijuana in the vehicle
I'm allergic
because the
to
car
marijuana.
smelled like, oh, you're allergic to marijuana, but y'all driving around with marijuana in the vehicle and the smell of marijuana. I find that very odd. I have some more luggage to unpack with her, but before I unpack that luggage, I want you to speak with probation, and then you're immediately going over to felony drug court.
Okay.
And probation, put her on the UA hotline. Everybody's allergic to marijuana, but they're always around it. All right. I guess maybe hot boxing was in the vehicle. Who knows? All right. Thank you.
Thank you.
Mhm.
Well, she is definitely not sold on what that defendant is telling her, and honestly, I can't blame her. I'm not sold either. Be curious to see where that goes. I'll try and keep an eye on it today in case she comes back, because she said she had more to unpack with her, so we'll see. Hope you all had fun today. I know I did. We started out on quite a note with Judge Middleton. I'm immediately after this going to go make that into its own video, so hopefully within the next hour or so you should see that posted to the channel, so keep an eye out, especially if you didn't see it earlier today, because it is definitely worth looking at. I appreciate all of you. Traffic has been a little bit down the last few days. That's been the case across YouTube. That is always the case once we get past Memorial Day and people have other things to do, but that means I really appreciate all of you who still take the time to join us. It's definitely means a lot, so thank you. We'll be back again tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour earlier for channel members. If you're not already a channel member, again, there is a link in the pinned chat. Check it out. I think it's worth it just for the pre-show alone, but we do a lot of other things too, and a lot more to come. So everybody go have yourselves a great Tuesday. Again, we'll see you tomorrow. In the meantime, take care and God bless.